Hello, you're watching Addleshaw Goddard's Employment Channel on the 21st of July 2011. In today's programme, we report in more detail on the Employment Appeal Tribunal decision in Garside and Laycock and Booth, where an employee was dismissed for refusing to take a pay cut. And we have a guest appearance from Stefan Brokvich-Lewinsky, an employment law barrister at 9 St John Street Chambers in Manchester, who acted for the appellant in this case. We also touch on a case that will impact on employers trying to strike out unfair dismissal claims at tribunal, for the time being at least. And finally, we look at a recent case involving a manager who was awarded nearly £400,000 for being dismissed after 5 months of sickness absence. Last week, we reported briefly on the Employment Appeal Tribunal decision in Garside and Laycock and Booth, an interesting development on whether an employer can fairly dismiss an employee for refusing to take a pay cut. It's an issue our solicitors are dealing with on a regular basis, and it's also topical, as given the current financial climate, employers are being forced to explore different ways to avoid redundancies. Stefan Brokvich-Lewinsky, who represented Garside and Laycock, comments on the case in more detail, including the practical implications for employers.
This is a useful case for employers in these times of austerity and cost-cutting. The company needed to make substantial cost savings. One measure it proposed was for staff to take a 5% pay cut. There was consultation, including meetings with the staff, explaining the need for the cut and the aim of avoiding redundancies. The company even put the issue to a vote. 77 staff voted in favour, 7 abstained and 4 voted against. Ultimately, only the claimant, Mr. Booth, remained as the sole employee who refused to agree to the pay cut. He refused various options offered to him, such as a wage review after 6 months, and eventually, because he wouldn't accept the reduced level of pay, he was dismissed. Mr. Booth brought a claim in the Employment Tribunal which found he had been unfairly dismissed. I was instructed by the employer before the Employment Appeal Tribunal, where that judgment was set aside. The decision of the Appeal Tribunal is useful because it recaps some of the law on these types of cases and gives some further useful guidance. It is made clear, again, that an employer can legitimately dismiss an employee in this sort of situation. In essence, the employer has to strike an appropriate balance between its own business needs and the needs of the employee on the other hand. A number of useful points come out of the judgment on appeal. Firstly, it is not correct that a pay cut can only be imposed where the employer's situation is so desperate that the only way of saving the business is to propose stringent reductions in pay and conditions. What must be shown is that there is a sound, good business reason, and then that a fair procedure is adopted in applying the change. In assessing fairness, the tribunal has to consider what it was reasonable for the employer to do from the employer's perspective. So, just because it might be reasonable for the employee to refuse the pay cut, this does not mean that the employer acts unreasonably in asking the employee to take the pay cut. Another relevant issue on the question of fairness was the fact that ultimately only Mr. Booth refused to accept the pay cut. It was recognised by the appeal court that the difficulty caused by one employee remaining on a higher rate of pay than other staff is a matter to be taken into account. Finally, the appeal court identified various other issues that might also be relevant to the question of fairness. These included the question of who was affected by pay cuts. So, for example, if the lower paid employees had to take a pay cut but management did not, that might render the pay cut unfair. Was a proper procedure adopted? For example, was the workforce provided with good, accurate reasons for the need for the pay cut? That sort of matter was taken into account. Overall, this is a useful and timely case for employers in the current challenging economic environment. It shows that, at least in this area, the law is keeping pace with employers' need to make what are sometimes tough decisions.
Thanks, Stefan. Next, we have an Employment Appeal Tribunal decision which could impact on unfair dismissal cases that have been listed for a pre-hearing review to consider strikeout. So, if you're currently involved in employment litigation involving a claim for unfair dismissal that arguably has no reasonable prospects of success, you'll need to be aware of this case and the consequences, particularly if you're considering applying for a pre-hearing review to strike out the claim. This is the case of Riley and Tayside Public Transport Company Limited. And here Mr Riley was sacked for driving a bus into a pedestrian bridge. The tribunal judge struck out the unfair dismissal case on the basis that Mr Riley's dismissal was within the range of reasonable responses, but this decision was overturned on appeal. Stefan again comments on this case in more detail and what this means for employers going forward. On this case.
This case involves the striking out of an employee's unfair dismissal claim at a pre-hearing review, that is, at a short hearing where the parties do not give evidence. The claim was struck out on the basis that it had no reasonable prospects of success, because the employment judge found, on the information before him, that the employer's decision to dismiss was within the band of reasonable responses. Lady Smith, in the Employment Appeal Tribunal, sitting in Scotland, set aside this decision, holding that the Employment Tribunal went too far, too fast, in holding that there were no reasonable prospects of success. Lady Smith found that the pre-hearing review, or PHR, was not a hearing to determine the facts surrounding Mr Riley's dismissal. Therefore, where there was a relevant dispute on the facts, it was not the right hearing at which to assess whether there were reasonable prospects of success. Lady Smith repeated what is often said, that striking out a case is a draconian power not to be exercised lightly, and said that the case should have been approached on the assumption that the claimant would prove all of the matters set out in his ET application to the Employment Tribunal. Given that these contained grounds for suggesting that the dismissal was unfair, it simply could not be concluded, Lady Smith said, that the case had no reasonable prospects of success. She also said that the question of whether an employer's decision to dismiss was within the reasonable band of responses was a matter to be determined by a full 3-member employment tribunal, not a judge sitting alone. It is this final comment by Lady Smith that makes this case interesting. Her earlier remarks that a PHR is not a hearing at which to determine evidence or to decide a case which turns on disputed evidence are what you would expect to hear. However, the suggestion that an evaluation of the reasonableness of an employer's actions in dismissing an employee cannot be made by a judge alone effectively limits very considerably the extent to which strikeouts may be made in unfair dismissal cases. Given that a full tribunal does not normally sit at PHR hearings, if this decision is followed, it means that it becomes very much more difficult to try to strike out unfair dismissal claims at pre-hearing reviews. While that might be good news for employees, it's bad news for employers who will now almost always have to incur the expense of fighting unfair dismissal cases to their full conclusion at full employment tribunal hearings.
Thanks, Stefan. So this case will certainly deter employers from applying to strike out an unfair dismissal claim at the PHR stage on the basis that the decision was outside the band of reasonable responses, as they may find themselves being hit with a wasted costs order. So it's certainly one to consider if you're conducting a cost assessment to defend such a claim. And finally, a recent tribunal decision which is notable as it sees the highest award for disability discrimination in Wales. And in Jones and Jewson, a branch manager was awarded nearly £400,000 when he was dismissed after 5 months of sickness absence. It's a stark reminder for employers of the inherent risks associated with dismissing employees on long-term sick leave. Not only does it remind us of the importance of following a fair capability process, including obtaining specialist and up-to-date medical evidence, which can often be lengthy and onerous, it also indicates that the way in which employers have dealt with long-term sickness absences in the past will be relevant and scrutinised by a tribunal when deciding whether discrimination has occurred. Here, Mr Jones suffered a stroke and went off on long-term sick leave. A medical report obtained by Jewson didn't mention whether he would recover fully, but it did say that to return to work, he needed a role that avoided stress. Jewson decided that no such role existed and Mr Jones was dismissed. He'd been absent for 5 months in total. Interestingly, Mr Jones ended up making a full recovery within 11 months. Jewson was forced to disclose statistics about its long-term sickness rates, which ultimately led to its downfall. The statistics show that a significant number of employees had been absent for more than 12 months before being dismissed. So, following this case, this appears to be a crucial factor for any employer to consider if they're planning to dismiss an employee on long-term sick leave. Whilst employers should always consider each matter on a case-by-case basis, they should also take into account the approach that they've adopted in the past. And if you're going to adopt a different approach, you'll need to be prepared to justify why. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.